Decision podcasts by the New York Prosecutors Training Institute are made possible by Resemble AI. Convert your text to voice at resemble.ai. Find this and other decisions at NYPTI Law. www.nypti.org/law.
People v. Marquise Scott, decided on March 18, 2025. Rivera, J. The issue on appeal is whether defendant Marquise Scott's guilty plea was knowing, voluntary, and intelligent. Supreme Court made an egregious error during the plea proceedings, repeatedly asserting that defendant faced up to 45 years incarceration if found guilty after trial, when his maximum exposure was statutorily capped at 20 years. As we have long recognized, inaccurate information regarding a sentence is a significant factor in determining whether a plea was voluntary. Given defendant's young age, his inexperience facing serious charges with the risk of consecutive sentencing, and the vast disparity between the plea offer of 6 to 8 years and the court's erroneous assertion that he faced 25 years more than the law allowed, we hold that defendant's guilty plea was not the result of a free and informed choice. Accordingly, defendant's plea cannot stand. 1. Defendant was charged with 3 counts of burglary in the second degree, CPL 140.25, 2, based on allegations that he unlawfully entered 3 dwellings, all on different dates. Around 1 year later, defendant appeared in court with counsel to discuss a negotiated plea in satisfaction of all charges. The prosecution put on the record that defendant, who was 23 years old, faced up to 15 years on each count, with a possible maximum consecutive sentence of 45 years. However, pursuant to off-record conversations with the court, if defendant pleaded guilty to all 3 charges that day, he would be sentenced to 6 to 8 years further. The court would consider an even lower sentence if the defense presented sufficient mitigation evidence before sentencing. With the plea offer on the record, the court addressed defendant directly and warned, "I'm looking at your file, I see there's 3 separate counts of the same burglary in the second degree which carries a range, from 3.5 to 15. Now, if a jury convicts you of all 3, the judge is supposed to tell you what the worst case scenario could be, which of course could be 15 plus 15 plus 15, that's where they get the 45. Following this admonition, defendant accepted the plea offer. The court immediately proceeded with the plea colloquy, during which it asked defendant if he understood that he was facing 15 years on each count. Defendant responded that he understood. After accepting the guilty plea, the court adjourned defendant's case for sentencing. During the subsequent pre-sentencing interview with the probation department, defendant stated that he pleaded guilty because he had a court-appointed lawyer and if he lost at trial he could face significantly more time. At sentencing, the court twice again told defendant that he faced 15 years on each count for a total of 45 years. Then, based on the court's conclusion that defendant denied his guilt during his pre-sentencing interview, it refused to honor the negotiated incarceration term and instead imposed an enhanced sentence of 5 years on each count, for a total of 15 years, followed by 5 years of post-release supervision. The court's repeated statements to defendant that he faced up to 45 years were legally erroneous. Although defendant could be sentenced consecutively on all 3 charges if found guilty, and each charge by itself carried a maximum sentence of 15 years, Penal Law 70.30, 1, capped defendant's aggregate sentence at 20 years. Thus, the court misinformed defendant that his outside exposure was more than double what the law allowed, adding 2.5 decades to the maximum time he faced if he were convicted of all 3 counts after trial, for an inaccurate aggregate sentence of close to half a century. On appeal, and represented by different counsel, defendant asserted for the first time that his plea was not knowing, voluntary, and intelligent, due to the court's misstatement of his potential maximum sentence. The appellate division concluded that defendant's challenge to his plea was unpreserved, and it would not consider the claim in the interest of justice. However, the appellate division reduced the enhanced sentence as harsh and severe to an aggregate term of imprisonment of 10.5 years. A judge of this court granted defendant leave to appeal. 2. Defendant reiterates his claim that his plea was not voluntary because the court erroneously advised him that his aggregate sentencing exposure was 45 years rather than 20 years. As a threshold matter, Contrary to the prosecution's contention, we may consider this issue on direct appeal. Ordinarily, a defendant must preserve a challenge to the voluntariness of their plea by moving either to withdraw the plea under CPL 220.603, or to vacate the judgment of conviction under CPL 440.10, see People v. Lopez, thus allowing the court that accepted the plea the opportunity to address the perceived error and to take corrective measures in the first instance, People v. Lowry. However, we have recognized an exception to this preservation rule where a defendant has no practical ability to object to an error, which is clear from the face of the record, People v. Peque. As we have explained, where the deficiency in the plea allocution is so clear from the record that the court's attention should have been instantly drawn to the problem, the defendant does not have to preserve a claim that the plea was involuntary because the salutary purpose of the preservation rule is arguably not jeopardized. We have applied this exception to challenges based on a court's erroneous statements regarding a defendant's sentence. In Lowry, the defendant did not have to preserve his claim that his plea was involuntary due to the court's failure to inform him until it imposed sentence that he would have to serve a term of post-release supervision. That error was plain on the face of the record and nothing in the court's statement suggested that its original description of the sentence was incorrect. And in People v. Diaz, one of the companion cases in Peque, the defendant did not have to preserve his claim that the court's failure to warn him that a conviction would make him eligible for deportation rendered his plea involuntary. Critically, the court in Diaz not only failed to advise the defendant about potential deportation but, like the court in the appeal before us, also provided defendant with inaccurate advice. The court implied that defendant's plea would entail adverse immigration consequences only for someone who was in the country illegally or had existing immigration issues, circumstances which did not apply to defendant. Given that the length of the sentence is typically a defendant's paramount concern when deciding whether to accept a guilty plea, our holding in Diaz applies to cases involving a court providing erroneous advice regarding a defendant's sentencing exposure. Where, as here, the court provides the defendant with erroneous information concerning their maximum sentencing exposure that is contrary to the undisputed text of the penal law, fails to correct its error on the record, and the defendant has no apparent reason to question the accuracy of that information, the defendant need not preserve a challenge to the voluntariness of the guilty plea on that ground. Here, the record makes clear that the court, the prosecutor, and defense counsel all mistakenly believed that defendant faced an aggregate prison term of 45 years if convicted on all three counts. Nothing on the record suggested that defendant's exposure was less than that which the court repeatedly stated authoritatively, and defendant therefore could not be expected to question that misinformation. As in Diaz, defendant's claim falls within Lopez's and Lowry's exception to the preservation doctrine. The prosecution's reliance on People v. Williams in arguing for a contrary conclusion is misplaced, as the case is easily distinguishable. Williams held that the defendant had to preserve his claim that his plea was involuntary due to the court's misstatements about his minimum sentence, which were based on the mistaken belief that he did not have a predicate felony conviction that would enhance that sentence. The preservation exception did not apply because, as we observed, the court expressed uncertainty during the defendant's plea colloquy about the legality of his promised sentencing options. These statements would have clearly prompted the defense to investigate and discover the court's error. Here, in stark contrast, the court's repeated assertions that defendant faced up to 45 years conveyed absolute complete assurance that it could legally impose that aggregate term. Moreover, the record in Williams was replete with other opportunities for the defense to seek clarification of the defendant's predicate status. The court had warned the defendant during the plea colloquy about the determinative nature of the defendant's predicate felony offender status. There were numerous adjournments between the plea and sentencing, and the court made specific comments at sentencing that offered an opening for counsel to confirm the legality of the court's sentencing options. The record here shows no such opportunities for defendant to discover the error and raise it with the court. The dissent adopts the prosecution's argument that because defendant did not move to withdraw his plea before sentencing, his sole recourse is a CPL 440.10 motion to vacate the conviction based on ineffective assistance of counsel. This ignores that defendant's challenge is based not on counsel's failures, but instead on the court's failures. Our precedent, and that of the United States Supreme Court, establish that the court has an independent obligation, grounded in due process, to ascertain whether the defendant is pleading guilty voluntarily. Pecky, see also People v. Ford, Boykin v. Alabama. That obligation includes an affirmative duty to ensure that the record is clear that the plea represents a voluntary and intelligent choice among alternative courses of action open to the defendant. Lowry, C. Boykin. The dissent disregards these well-established due process requirements, which are fundamental to our criminal legal system, through its insistence that defendant may only file a motion based on an entirely different legal argument. That counsel may also have failed to discover the error following the court's unwavering statements of a 45-year aggregate term does not absolve the court of its constitutional obligation to ensure that defendant's guilty plea is knowing, intelligent, and voluntary. Indeed, in any case where the court makes an erroneous statement regarding a sentence, forgets to explain a direct consequence of a guilty plea, or otherwise does not ensure that a guilty plea is voluntary, defense counsel may always step in to correct the error. We have never held that defense counsel's failure to do so, even if it provides a basis for a CPL 440.10 motion, precludes a defendant from separately challenging on direct appeal the voluntariness of their plea due to the court's dereliction of its own constitutional duty. Regardless of the merits of any CPL 440.10 motion, defendant has raised a challenge to the voluntariness of his guilty plea, and we apply our rules regarding preservation of such challenges to conclude that we may reach its merits. The dissent, by arguing that defendant may only challenge the court's error indirectly through a claim that defense counsel was ineffective, seeks to depart from our precedent and extinguish the exceptions we have wisely recognized as necessary to ensure that a court fulfills its crucial constitutional duty. Thus, contrary to the dissent's contention, we are not creating a new standard, but rather applying the facts to our existing doctrine. The dissenters' litany of questions about the scope of the preservation exception may reflect their dissatisfaction with that exception, but they do not cast any reasonable doubt on our strict adherence to precedent in this appeal. Nor does our holding risk, as the dissent fears, opening the floodgates to appellate courts with unpreserved claims. As an initial matter, the appeal before us is assuredly rare. We presume that courts are aware of the law and have a baseline understanding of the sentencing statutes they are charged with implementing daily. Unlike fact-specific aspects of sentencing related to predicate status, or open legal questions about ambiguous statutory language, Penal Law Section 70.30, 1(e)(I) contains no gray area. Defendant's sentence was mandatorily capped at 20 years, and there was no justification for the court to read this decades-old statute otherwise. We further reject the dissent's assertion that our application of precedent to this appeal may incentivize a judge to simply avoid stating the defendant's maximum exposure before taking their plea. Where, as here, a defendant's maximum exposure is clear, a judge has no reason to keep that information secret. Even if there were some questions about a defendant's maximum exposure, a judge may simply acknowledge that uncertainty by, as one example, warning that it is unclear if the defendant is eligible for consecutive sentencing but explaining the defendant's possible sentencing exposure in either circumstance. Like in Williams, a judge's expression of uncertainty would cue a defense attorney to investigate further and discover any errors. The dissent provides no reason to believe that judges are incapable of identifying and explaining these uncertainties as part of their independent constitutional duty to ensure that any plea is knowing, voluntary, and intelligent. More fundamentally, holding, as the dissent advocates, that claims such as defendants fall outside the preservation exception would only increase litigation in appellate courts, not reduce it. Under that rule, defendant may still raise an unpreserved challenge to the appellate division and invoke the court's interest of justice jurisdiction, see CPL 470.15, 3, c. 6. Although the appellate division declined to exercise that authority in this appeal, it routinely relies on it to address and remedy unpreserved claims of error, including challenges to the voluntariness of a guilty plea, see for example, People v. Lumpkin. Although defendant's contention that his guilty plea was involuntary is not preserved for our review due to the lack of an appropriate post-allocution motion, we nevertheless exercise our interest of justice jurisdiction to take corrective action, People v. Drayton, in view of the plea colloquy, sentencing minutes and defendant's request, we deem it appropriate to exercise our interest of justice jurisdiction and vacate defendant's guilty plea. Thus, narrowing the scope of the preservation exception would not prevent a defendant from raising an unpreserved challenge to the voluntariness of their guilty plea on direct appeal. As in this appeal, the appellate division would still review the record to determine if exercising its interest of justice jurisdiction is appropriate. Additionally, that defendant would have to file both a direct appeal and a CPL 440.10 motion, creating two separate litigation tracks raising issues that easily could have been addressed in one, and if the trial court denied the CPL 440.10 motion, two separate appellate processes. This is a waste of judicial resources. It would also increase the number of pro se submissions, which impose special burdens on courts and defendants, because defendants do not have an automatic right to counsel to assist with CPL 440.10 motions. See County Law Section 722, 5, granting courts discretion to appoint counsel to assist a defendant with a CPL 440.10 motion if they also have a pending direct appeal. Finally, the dissent's accusation that our holding disincentivizes defendants from correcting the trial court's misstatement of their maximum possible sentence and lead to gamesmanship is entirely unfounded. Setting aside that the dissent offers no empirical evidence to support its cynical view that defendants and their attorneys conspire to leave errors uncorrected to tee up appellate issues, its claim is implausible as a general proposition. It strains credulity to believe that a defendant would risk their liberty and plead guilty solely on the outside chance that an appellate court would vacate their conviction and order a new trial some years in the future. Even if that defendant were successful on appeal, they will already have been incarcerated for years, and there is no guarantee against the prosecution offering a worse plea deal or the case proceeding to trial, where the defendant would risk being sentenced up to their maximum exposure if found guilty. The dissent's point that as time passes, evidence is misplaced, witnesses disappear and once vivid memories of a crime begin to fade into uncertainty, id, quoting People v. Jackson, may just as easily prejudice a defendant as the prosecution. An alibi witness may pass away, or an exculpatory video may be deleted. These risks make any gamesmanship a costly endeavor too extreme to believe that defendants are willing to accept them. Accordingly, the dissent's baseless claim is no reason to depart from our settled precedent. For these reasons, direct review is appropriate to assess the impact of the court's erroneous statements on the voluntariness of defendant's plea. 3. Turning to the merits of defendant's challenge, in order to be valid and enforceable, a guilty plea must be entered voluntarily, knowingly, and intelligently. People v. Brown. A guilty plea is voluntary only if it represents an informed choice freely made by a defendant among other valid alternatives, citing North Carolina v. Alford. Whether a plea is knowing, voluntary, and intelligent depends on the totality of the circumstances. We must consider, among any other relevant factor, the nature and terms of the agreement, the reasonableness of the bargain, and the age and experience of the accused. People v. Hidalgo. A defendant receiving inaccurate information about their sentencing exposure is another factor which must be considered by the court. People v. Garcia. Based on the totality of the circumstances, defendant's plea was not voluntary, knowing, and intelligent. Defendant was only 23 years old at the time of his plea, and his prior experience with the criminal legal system did not involve any offenses that would prepare him to contemplate felony terms of incarceration, let alone consecutive sentencing of multiple offenses. As the prosecution stated on the record that the plea offer was valid so long as defendant pleaded guilty that same day, defendant was under immense pressure to give the court an immediate answer. And the court egregiously misinformed defendant that his sentencing exposure was 45 years if convicted on all three felony counts 15, plus 15, plus 15 when by statute his aggregate sentence was capped at 20 years. This 25-year differential between the court's erroneous calculation and the time permissible under the law was a significant factor inducing defendant to plead guilty and take the 6 to 8 year offer. Indeed, defendant reported to probation that he pleaded guilty to avoid facing considerably more time if convicted at trial. That statement is unsurprising, as a defendant might never plead guilty absent the possibility or certainty that the plea will result in a lesser penalty than the sentence that could be imposed after a trial and a verdict of guilty. Brady v. United States. Although no one factor is dispositive, and we consider the totality of the circumstances to reach our holding, we cannot minimize the extreme nature of the court's egregious error and its impact on defendant's judgment. The court presented defendant two options: 1. Accept the plea with the possibility of release in his late 20s, and the promise of a long life at liberty, or 2. Go to trial and if found guilty spend close to half a century in prison, and walk out in his 60s, with more time left behind than ahead of him. That is no choice at all, for no matter how strongly one believed in their defense, it is difficult to imagine anyone in defendant's position willing to take such a risk. With the apparent stakes so high, defendant's plea was not voluntary, knowing, and intelligent as a matter of law. Accordingly, the appellate division order should be reversed and the case remitted to Supreme Court for further proceedings in accordance with this opinion. Order reversed and case remitted to Supreme Court, Erie County, for further proceedings in accordance with the opinion herein. Opinion by Judge Rivera. Chief Judge Wilson and Judges Canataro, Troutman and Halligan concur. Judge Singh's dissents and votes to affirm in an opinion, in which Judge Garcia concurs. Decided March 18, 2025.
Decision podcasts by the New York Prosecutors Training Institute are made possible by Resemble AI. Convert your text to voice at resemble.ai. Find this and other decisions at NYPTI Law. www.nypti.org/law